in Dallas, Texas is now in session. Justice Peterson presiding.
Good morning, everyone. Thank you all for being present and indulging us and cooperating with oral argument over the web. I'm sure both of y'all are very familiar with our timing. You see the timer in one of the screens, 20 minutes for the appellant, then 20 minutes for the state of Texas, and then 5 more minutes for the appellant. We used to say, turn your phones off. Now we hope everybody's dogs are in a different room. So I'll go ahead and call the case. It's 0519-01035-CR, Guillermo Suarez versus State of Texas. Both sides present and ready?
You are, Your Honor.
Yes, Your Honor.
Thank you very much. Okay, well, Mr. Illich, you may begin whenever you're prepared.
Thank you. Justice Peterson, and may it please the court. My name is Niles Illich, and I represent Guillermo Suarez. In our first issue, we contend that the evidence is legally insufficient to support the finding that the second enhancement paragraph, the aggravated assault from 2012, was true. The state had to establish that the first conviction became final, and then the act that resulted in the second offense occurred. In Jones, and there are two Jones cases here, one from 1986 and one from 2002, and I'm referring specifically to the one from 2002. In 2002, the Court of Criminal Appeals established that the state makes a prima facie case that the convictions are final with a copy of the certified judgment. According to Jones, that prima facie case is legally sufficient evidence if there is no evidence to the contrary. Here, we contend that there is evidence to the contrary, and that this evidence is the temporal proximity of the date of the sentence and the date of the criminal act in the case. We contend this is Jones' evidence that the judgment was not final.
Mr. Illich?
Yes.
In Jones, wasn't the time span at issue even less than the deadline for the notice of appeal?
It was, Your Honor, but I think the point of that, Justice Rycheck, is that Jones says that the evidence is legally and factually sufficient to prove a prior conviction if a final conviction, absent any evidence to the contrary. So the point is that the temporal proximity we have here is some evidence that the conviction was not final. In other words, the certified judgment by itself isn't enough. And we've laid out a timeline for why that would be in this case. And I really think that the standard that the Court of Criminal Appeals announced in Jones is really comports with that which has been announced in the Fifth Circuit, but I think it's more developed in the Fifth Circuit. And what it says is that a judgment is presumed to be final if the passage of time alone precludes the reasonable possibility of an appeal. Our brief sets out why, and I don't want to go through the time here because there are many, many ways in which it can be calculated, but it shows why there is not a reasonable possibility that an appeal is concluded. In other words, there is a very open possibility that an appeal is continuing. And we contend that this is Jones' evidence that precludes the state from relying simply on the certified judgment. And they needed to go a step further because of the temporal proximity between the Enhancement Act and the underlying criminal act.
Mr. Illich, I'm sorry to interrupt you, but I'd like for Mr. Gladden to address this when it's his opportunity. Does anybody have any idea why there wasn't one of those 26.2 certifications in the, we make everybody fill out that form whenever you're resolving a case. This appears the judgment sentence that appears to be in question here was a plea bargain agreement for back time, as I understand the record. Does anybody know why we don't have a 26.2 certification, and does that matter?
Just Peterson, I don't think anybody's going to be able to tell you why we don't have that. The record is silent on that. And we might be able to speculate based on our experience, but I don't think that's really appropriate to do here. So the record is silent on that. And I don't think it matters that we don't have that. I think what matters here is as I've said, is the temporal proximity, that these are close enough that we can't reasonably presume just on the dates that there was no appeal. Now we can look and say, it was a plea bargain and all these other things, and there probably wasn't an appeal. But those things aren't in the record, and we have to go outside of the record to reach those conclusions. And these things were fairly easy for the state to introduce in trial. They just didn't. They relied on the certified judgment, and in our contention, that wasn't enough. But if this court finds that it's enough, I think that takes us to our second issue, which is that the trial court erred in not defining the term final as that related to the enhancement offenses in the jury charge. And when I look at the briefing and reviewed this in preparation for today's argument, I think that the thing that was sort of neglected until the reply brief is the truism that a jury can accept or reject any evidence that it wants. So while the final judgment may or may not ultimately be legally sufficient evidence of a final conviction, that doesn't mean that the jury had to accept that evidence. The jury can reject almost any evidence that it wants.
What definition would you have offered, Mr. Illick?
The definition of final, I think you would say that a judgment is final when it has not been appealed and the time for the appeal has expired, when an appellate mandate has issued, give the jury the criteria to determine those, because I don't think final is a definition that the jury could sort of take from the plain meaning of the word final and apply. They don't have any idea what a mandate is. They don't have any idea what the appellate timetables are. And so here, we can't just sort of rely on what we normally rely on and say the jury could use their normal understanding of the word final to interpret whether this was a final one. The judge needed to give the jury the tools to make the assessment of finality here. And remember, this is really the only issue here in dispute, because the client changes his plea to guilty, and so they don't have to do the guilt and innocence. The only real thing that matters here is, do these enhancements apply? And it really does matter. Were you going to ask a question? Did I cut you off? Okay. It really does matter because we're talking about a sentence from 2 to 20 years or 25 to life. And so this definition of final, this notion that simply entering a judgment is not enough, is something that needed to be put before the jury. The jury needed to have the tools to assess the evidence that was placed before them. And
Mr. Illick?
For them not to. Yes, Justice Reichek.
If we find that the state met its burden of establishing finality, did your client suffer any harm with this, what you allege to be a charging error?
Yes, Justice Reichek, I think they did. And of course, we would have to turn to the 4 Almanza factors to do that, because this was unobjected to harm. And I think the first thing we would note is, just in a general sense, before I get to the 4 Almanza factors, is that if you find that the evidence is sufficient, I don't think you're going to find that it's sufficient by clearing the bar by a huge amount. If it's sufficient, it cleared the bar by a small amount. It barely went over the bar. And then we have this notion of it's final, but the jury didn't understand what final meant. So I really think that's where the harm was. The jury could have rejected this notion of finality, this notion that just the certified copies establish finality had they been given these tools. I'm sorry, I'm getting something strange on my screen here. I hope that worked. But they weren't given those tools, and so they couldn't assess finality. And that's really where I see the harm. And that harm takes it from a 2 to 20 year sentence to a 25 to life sentence. But if we go to the 4 Almanza factors, which I think is what you're referring to, I think the first one is the entire charge. And when we look at the entire charge, I think that the principal issue here was finality, but the jury wasn't given the tools to make this determination. Had they been given the tools, they could have looked to this and seen the silence about finality and found these not to have been true. The second is the state of the evidence. And when we look at this, again, I think it's the same argument. There's a small, if you find the evidence to be legally sufficient, it clears the bar only by a small amount. And if it only clears it by a small amount, the state of the evidence supports the finding of egregious harm. When we look at the arguments of counsel, I think that's neutral, because I don't think the attorneys argued that. But the most important one is this fourth one, where we look at the entirety of the case. Now, we haven't talked about the facts of this case, Justice Rychek, because my client changed his plea to guilty. And so a lot of what happened didn't matter. But the jury heard 4 or 5 days of really emotional, evocative, painful evidence that I did not enjoy going through, and I'm sure was convincing for the jury. And they needed this definition of final to avoid rendering a emotional verdict. This is a jury who would have been emotionally primed to find my client guilty and to impose a large sentence, but they needed the tools to understand what finality was in order to make a proper assessment in this case. So yes, this is a very long answer to a short question, that yes, I think there's error, and yes, it is harmful. Now, my third argument deals with substantial compliance under Article 26.13. I'm not ready to sort of capitulate or concede this point, but I ultimately think this court is going to have to find that the state is right on this. I don't think the trial court did it correctly. I think they left things out. That's all been set out in the brief, but they did do sort of, arguably, is the bare minimum. So I think my time is better spent turning to my final issue, and that is the motion for new trial. And in this final issue, I risk a little bit appearing to pander to this court, and maybe even in particular to this panel, but that's not my intent. What I want to say is that this court has done a commendable job in protecting the rights of appellants whose attorneys file Andrews briefs. And the issue that I bring is really brought in that same spirit. And it might be easy to say that motions for new trial are rarely granted, or they aren't important, or we really don't think they have much of a role in criminal cases anymore. But these are critical stages in the prosecution to which the Supreme Court and the Court of Criminal Appeals say that a person is entitled to representation. I've been fighting this battle about the form for motion for new trials for many years. And Doug was right to cite to the Skinner case. That's a case I wrote, a brief I wrote maybe 2016 when I raised the same issue. But here we have a really clear example. We have a defendant who changes his plea from not guilty to guilty. And then at about 1 o'clock on the day he is sentenced, his attorney files a motion for new trial that says that the law and the evidence don't support the verdict, not the sentence, the verdict. But here, the defendant admitted he did it. He changed his plea. He went through admonishments. He said, I'm guilty. And if that isn't enough, I don't really know what is. But we understand what's happening here. This is a form motion that attorneys in Dallas County routinely file, and they file it at the encouragement of the trial court because it gives these overworked court reporters additional time to file their records. I understand that need, but it isn't done in the client's best interest. It's done as a matter of form, as a matter of procedure in the trial court in order to help the court reporter. It waives a critical stage in the prosecution by filing a motion for this. Now,
Mr. Ellick,
yes,
what should the motion for new trial have raised? What were the meritorious issues that were omitted?
Well, that goes into harm, and I think I'm happy to answer your question, but what I want to say is that goes into harm, and I'm raising this under chronic, under which harm would be presumed. So if I was going to file a motion for new trial in this case, I think I would argue most of the points that I've argued here. In other words, that the trial court made an error in not defining final in the jury charge. And these are issues that I think an appellate attorney can come in and bring up in a motion for new trial. But when, as here, you get this form motion that's filled in by the attorney and overruled by the judge on the same day within minutes of the sentence coming in, the appellate attorney doesn't have that opportunity to come in and make this argument. Because once they've overruled the motion for new trial, it's gone. You can't raise it again. Now, if they hadn't overruled it, I could have come in and filed a motion for new trial. So it's a long answer to a short question. But the answer is, I don't think I have to show prejudice because I'm bringing this under chronic. And I'll get to why it's chronic instead of Strickland in just a moment. But even if it's brought under Strickland, I think we can see prejudice because there were legitimate issues that could have been brought to the trial court and could have been resolved there instead of simply waiving them by filing this motion. Now, what I contend has happened here is that this is the complete deprivation of counsel at the motion for new trial stage. The entire complete deprivation. There's no thought, there's no consideration of the merits of a motion for new trial. There's no consideration of, is the client better off with this? It is simply a question of benefiting the court reporter, and that is a chronic claim. Now, in Skinner, Justice Fillmore rejected that claim, and he addressed this under Strickland. But I think Justice Fillmore was wrong, and I think he was wrong. And Skinner was a closer case because it wasn't a guilty plea. Here we've got a guilty plea where they simply say guilty, but the law and evidence don't support the verdict. It's not that it doesn't support the sentence, it's that it doesn't support the verdict. A verdict where the guy said, hey, I'm guilty. I don't understand it. But in Skinner, Justice Fillmore analyzed it under Strickland. I don't think it belongs under Strickland. It belongs under chronic. Accordingly, appellant asked this court to find that his counsel was constitutionally ineffective at the motion for new trial stage. I can't see my clock, and so I've gone a little bit fast here. But if the court has no further questions, I'm happy to yield to the state.
On issue 4, do we have to overrule Skinner to get where you want to go?
No, Justice Whitehall, I don't think you have to. First of all, Skinner is an unpublished decision, but it was done under Strickland. So all this court has to do is to say we're deciding it under chronic. And I think if you decide it under chronic, because the facts are different here than they were in Skinner, I think you can say we acknowledge Skinner, but we decide this one under chronic and we find counsel ineffective.
Any other questions?
For me.
Thank you very much, Mr. Illick. Did I say your last name correctly, Illick?
You did. Thank you.
Very good. Thank you. Mr. Gladden, whenever you're prepared.
Thank you. Good afternoon, or good morning. May it please the court. My name is Doug Gladden. I represent the state of Texas in this case. I think I'll go straight to Justice Whitehill's question in regard to the 4th issue, just because it's fresh on my mind. Does this court have to overrule Skinner to rule for appellant? I think I agree with Mr. Illick that no, you don't have to overrule Skinner because, as he says, Skinner is a unpublished opinion from this court. But my argument is you don't have to rule for appellant in this case because Skinner is correct and Skinner does apply to this case. In Skinner, what this court did is it looked at a claim that filing a form motion for new trial was ineffective under chronic. And the court said, no, it's not a chronic issue because counsel did something. What a chronic claim requires is that there be a total deprivation of counsel. And so when you're asking whether what counsel did was deficient, you're looking at an action. That's the difference of kind rather than degree that the Supreme Court said is the difference between a chronic claim and a Strickland claim. So when there is a motion for new trial, no matter how much appellate counsel disagrees with what was done in that motion for new trial, there is performance by trial counsel. So there is not total deprivation, and so it's not a chronic claim.
So your view is then that this completely incompetent motion for new trial that challenges basically the defendant's plea of guilty is assistance of counsel? Even though you have to agree it's totally ineffective.
Well, no, Justice Peterson, I don't agree that it's totally ineffective, and I'll tell you why. Ineffective assistance of counsel requires two things. It requires what you call incompetence and prejudice if we're looking under the Strickland standard. And so you don't, even if counsel is incompetent, counsel is not constitutionally ineffective unless there is a likelihood that the result of the proceeding would have been different. And that's what this court recognized in Skinner. This court said, look, you've only identified one ground that could have been raised in the motion for new trial, and that ground's not meritorious, so you haven't shown prejudice. Well, here, Mr. Illick, in his brief, didn't identify anything, and I relied on that in arguing that he didn't show prejudice under Strickland. I think during argument, he said he would have raised the jury charge, but I can get to in a minute why that would not be a meritorious ground. So I think to show prejudice under Strickland and to show ineffectiveness under Strickland, he has to show that whatever would have been raised would have been granted. And I don't think he can do that in this case. One thing I want to bring up just for this court's reference is I found this last night getting ready for argument, so I didn't have time to file a supplemental letter. But the 14th Court of Appeals just recently looked at what constitutes total deprivation of counsel during the motion for new trial stage. That case is Calhoun v. State, and it's at 2020 Westlaw 4211722. The issue in Calhoun was that the defendant was convicted and his attorney withdrew before filing a motion for new trial, and then appellate counsel was not appointed until after the 30-day window had passed. And the 14th Court of Appeals said that that constitutes total deprivation of counsel at the motion for new trial stage, when there is no legal assistance whatsoever. But that anything less than that is not total deprivation. And then the court went on to say that under the Cook's standard, which is the Court of Criminal Appeals case that says a motion for new trial is a critical stage, you have really 3 stages in your analysis. And under that standard, you have your prejudice analysis for Strickland, but then you also have to do a harm analysis if you find deprivation of counsel. And so when Cooks looked at the deprivation of counsel, Cooks looked at the deprivation of counsel, they said that if the defendant is represented by counsel at trial, there's a rebuttable presumption that counsel continued to adequately represent him during the motion for new trial stage. But if the defendant rebuts that presumption, the court has to do a harm analysis, not a prejudice analysis under Strickland, but a separate harm analysis to determine whether then the defendant was prejudiced. In Calhoun, the court said you rebut the presumption by showing no counsel whatsoever. And then you do a harm analysis after that to determine whether or not to abate for a new motion for new trial hearing. But in this case, we don't even get to that point because there was counsel. Trial counsel was there. Trial counsel did something. Trial counsel filed a motion for new trial. The appellant doesn't like what was in it, but he did file a motion for new trial. And so the question is whether there was deficient performance, not a total deprivation of counsel. That's a Strickland claim, and so this is not a valid chronic claim. To go up to, I just, with my time, I do want to answer all of the panel's questions that were asked. So Justice Peterson, I believe that on the first issue, you had a question for me about why there wasn't a certification in the record.
If anybody knows, and you probably don't, but
I don't.
Sure filling those forms out when I was resolving my criminal cases is just another form I had to fill out and write my address 4 times. And so
right,
frustrating to not see it in the record, right?
I actually think I know why there's not a certification in this record. And the reason why there's not a certification in this record is because it's not required in this record. What the Court of Criminal Appeals has consistently said is that when you're proving sequential prior felony convictions, the state meets its burden of proof by introducing the judgment and sentence. The certification is not part of the judgment and sentence. So even if a certification existed in the records from the prior criminal case, that doesn't automatically mean it's going to be in the records introduced in this case, because typically the way we put the judgment and sentence into evidence to prove up priors is to use the pen pack. And I don't want to say definitively because it's been a while since I've read this provision of the code, but I don't believe the pen pack has to contain that certification. And if it doesn't have to contain the certification, then it's not going to be included in the record when it's proved up as a prior. And so that burden that the state has and the way the state meets that burden of proving the sequential prior felony convictions, introducing the judgment and sentence, that's a long-standing law. That's not something new that the Texarkana court announced in Davie. That goes back to Fletcher in 2007, Jones in 1986, D'Armigio in 1982, which said that it was settled law in 1982, referencing back to Johnson in 1979, all the way to Ashley v. State in 1975, which was the first case to interpret the new penal code that was passed in 1973. So this has been settled law since the penal code was passed, that the state makes a legally sufficient prima facie showing of a final prior conviction by introducing the judgment and sentence when the record shows that when the record doesn't show that there was an appeal. At that point, and this has always been the case, at that point the burden shifts to the defendant to show that there was an appeal. And if the defendant doesn't show that there was an appeal, he's done nothing to rebut that presumption of finality. And if he hasn't rebutted the presumption of finality, then there's no factual issue. So there's no need for a jury charge to define finality because there's nothing for the jury to decide, and the evidence is legally sufficient. Now, Mr. Illich is pointing to the appellate timeline. And I know specifically he says that we can't presume that an appeal would be complete within 485 days, which I think is roughly the time between the conviction and the new offense. But the appellate timelines don't matter. Under state law for a 1242 enhancement, the appellate timelines just don't matter. They may matter in the Fifth Circuit under the Controlled Substances Act or the sentencing guidelines, but they don't matter under 1242, and here's why. If there was no appeal at all, then we don't care when the mandate issue, because there will never be a mandate. And if there was an appeal, then it doesn't matter if that mandate issued 30 days after conviction or 3 years after conviction. What the Court of Criminal Appeals has said is that if the defendant produces some evidence that he appealed the conviction, the state has to introduce a certified copy of the mandate. This isn't like the Fifth Circuit where we can come in and say, oh, there was a sufficient period of time on an appealed case. That's how we're going to presume that it was final. What the Court of Criminal Appeals case law that I've read says that if the record shows there was an appeal, we have to introduce a certified copy of the mandate. So that's all that matters. The timelines just don't matter. But here, there's no evidence that there was an appeal at all, so the state didn't have to introduce a copy of the mandate. The state satisfied its burden by introducing a copy of the judgment and sentence, and that's why the evidence is legally sufficient. And that's, as I said earlier, that's the same reason why the jury charge didn't have to define final. When there was no disputed fact issue about the finality of this conviction, there was nothing for the jury to decide. Now, I will note that when it comes to situations where there is a disputed factual issue, which is not this case, then there's still some disputes about what the law even requires. By my research, none of the suggested pattern jury charges in Texas provide for a definition of finality. The Texas criminal pattern jury charges produced by the state bar specifically recommend not defining finality because it could be confusing. And as Mr. Illich pointed out, the reason why is that one of the definitions of final is that if the case was appealed, we wait to see when the mandate issues, but the jury doesn't know what a mandate is. So you run the risk of just having this daisy chain of definitions that could confuse the jury. But Berry and Gallagher also give no definitions, and McCormick's gives no definitions in their pattern jury charges. The other thing I'd want to point out for the purpose of just harm analysis to look at is some of the courts of appeals have treated the finality issue as a defensive question. And that makes sense because the law says that the state meets its burden by presenting a prima facie case, and then the burden shifts to the defendant to make some rebuttal of that to show that it wasn't final. If that's the case, then non-finality of a conviction is a defensive issue. And if it's a defensive issue, then Almanza doesn't apply. A defensive issue has to be requested by the defense attorney to be evaluated for jury charge error, even under the Almanza standard. So if we're going to look at this as a defensive issue, then I don't think, even if this court finds error, I don't think it has to do an Almanza analysis, because here the defense didn't ask for the jury to be instructed on the finality issue. Instead, the state introduced a prima facie case, and it sat at that. When I looked at the closing arguments, the only thing I saw from the defense on this point is they argued to the jury, hey, if you feel sympathetic for the defendant after the punishment phase, then you can essentially nullify the enhancements by finding them not true. There was no discussion of finality. It was more of a argument to the jury's emotions and sympathies. So there was not even an argument, much less evidence, that would put finality into play. I appreciate Mr. Illick doing his best not to fully concede the third point, but to recognize that the state is right on this issue. I just want to point out one thing that I found preparing for trial, or preparing for this argument, that I didn't put in my brief. And that is, in the brief, I argued for the sixth admonition that failure to give it is not grounds for setting aside the plea under 2613H1. And I sort of rested on that because that's all I could find. As I was looking through the record in this case, I think that the sixth admonition falls into the same category as 2, 3, and 5 in this case, which is it's not required because it doesn't apply to appellant's case. Appellant had prior felony convictions. He didn't file a request for probation before trial. And so there was no way he would have been eligible for community supervision in this case. If he's not eligible for community supervision, he can never be eligible for judicial clemency, which is what the sixth admonition is referring to. And so if it's not applicable to his case, then the substantial compliance for the admonition is to not give it at all. And that's what we see with number 2 and 3. That's what the court said in Jamel v. State, that if it's not a plea bargain, substantial compliance is not to admonish about the consequences of a plea bargain. I think that carries over to judicial clemency admonishments, as well as the sex offender registration admonishments that I discussed in the state's brief. If this panel has no further questions, I'll give you the last 5 minutes back.
I have one question. It's just for my edification. When you cite to 6.13H, when I look in my 2020 Westlaw Code of Criminal Procedure, it appears under, are we sure? I'm sorry, that's just E. Forget it. No questions. Sorry.
Okay. It's quite all right.
Any other questions from anybody else on the panel?
Nope.
Thank you very much, Mr. Illick, whenever you're prepared.
Thank you.
Sure. Very quickly, and I guess that's how all rebuttal arguments start. But I think we've missed the point on chronic a little bit, and we cite to it in the brief here. And the real test in chronic is an attorney who fails to provide any meaningful legal assistance to their client. And it's characterized by the inert and potted plant lawyer. You can look to 466 U.S. 659, and I think you see that the real test here is an attorney who failed to provide any meaningful assistance to his client. And that's exactly what we have here when we talk about this motion for new trial. This motion for new trial doesn't talk about the sentence. It talks simply about the verdict. This is a verdict, as Judge Peterson said, where the client admitted he was guilty, and then the motion for new trial basically goes against his own plea. There is no meaningful legal assistance provided in this. It's simply a form done to accommodate overworked court reporters. I don't begrudge the court reporters for wanting it. I do think, though, attorneys have a duty to stand up and say, I can't file that. I have to represent my client in this matter. Turning to the jury charge error, the trial court had a sua sponte duty to provide all the law that was necessary for the jury to decide this case. The question to the jury was whether or not these two enhancements were true. And without knowing whether or not these are final, without having a definition of finality, the jurors simply lacked the tools to make that determination. It is a fundamental failing. I don't believe for a moment that this is a defensive issue. This is an issue brought forward by the state, advanced by the state, as they have the right to do under 12.42, but they have the burden to prove it. In most cases, the judgment, the certified judgment, is going to be sufficient. In this case, we contend it wasn't. But even if it wasn't sufficient, excuse me, the lights went out. Even if it wasn't sufficient, the jury still should have been empowered with the tools necessary to make the proper determination. And if you have any questions about it being a defensive issue, I think you can look to the 2002 case in Jones, that's 77 Southwest 3rd, 822 through 823, where the court says that the evidence is legally and factually sufficient. The evidence of a finality is legally and factually sufficient, absent any evidence to the contrary.
Did Mr. Suarez appeal that judgment?
I'm sorry?
Did Mr. Suarez appeal that judgment?
I have no idea, Judge Whitehall. I haven't looked into that. It certainly isn't in the record, and my inclination would be to say that probably he didn't.
Right. So there's no evidence in the record indicating that he appealed that judgment. Is that right?
There is absolutely no evidence indicating that he appealed the judgment, nor is there evidence indicating that he didn't appeal it. It's just an open question, and that's exactly the problem. The state
would Mr. Suarez know if he appealed the judgment?
Presumably he would know. He seems to have had quite a bit of experience in the legal system, and so I assume he would know that. Yes. But the point is, the jury needed to make that determination, and by not defining the term final in the jury charge, the jurors were not empowered to make that determination. With that, I will rest and see the remainder of my time.
Thank you all very much. We sure appreciate your excellent argument and briefing, and the case is submitted.
Thank you.
Thank you.
Thank you.